We're here on another episode of Ask Judge Edie, and where are we located right now? I see all the books.
Yes, we are in the genealogy record room of the probate court that's located on the second floor of the courthouse. So we have all of our public records in this room. Fascinating if you had the time to review them. We have all the records for marriage licenses, wills, estates, year support, some fun things like estates and apprenticeship records. So
Oh, wow.
Those are some historical records that we have here in the courthouse.
Perfect. So, and a lot of the records are, you said from, was it 1998 forward? A lot of these are online?
Yes, I believe 1998 forward.
Okay.
You can go to georgiaprobaterecords.com, and all the records of this probate court are online. So these are our historical records, basically, prior to that time.
Okay, very good. So estates are a big part of real estate, with what we do, and you know, we met years ago, obviously, from
Right.
real estate closings, being a real estate attorney, and you know, I've been on the wrong side of not understanding the estate probate process.
Right.
Someone calls, hey, someone passed away, we need to sell the property. Okay,
Right.
didn't know the right questions to ask, and market the property, find the buyer, take it to closing, only to realize right before closing that we can't close because the estate was not properly probated, and it's just kind of like it halts everything. So
That's right.
Tell us a little bit about how that process should work, the right questions as real estate practitioners to ask, or just people that have had a loss of a family member, or anything else that's pertinent to be able to help make sure this goes through so it's a smooth transition for everyone involved.
Right. Probate is the disposition of assets of a person who has passed away, so a decedent. And for as many different types of people there are, and as many different circumstances there are that many different ways that probate can be handled. But any time you have a person pass away that owns assets, generally it's going to be required to go through probate. There are some circumstances where assets pass by operation of law automatically.
Okay.
For example, a joint bank account generally passes to the survivor on that bank account.
Or like joint tenants right of survivorship, like when I bought
Exactly.
my house and my wife and I own it together.
Yes.
If something happens to one of us, it just passes to the other one.
That's right. Joint tenancy right of survivorship is a perfect example. That happens automatically by operation of law and the fact of that type of deed. But if there's any assets that do not pass automatically by law, those assets will have to go through the estate and have to be administered through the probate court. Generally, the easiest way for that to happen is if there's a will. I will say that, and in the will, it can provide processes. Georgia allows a will to include provisions that make it easy to probate and administer that estate. I will say, generally, Georgia probate is can be one of the easiest processes to navigate, but you have to have the correct provisions in your documentation.
So I know that you can't give legal advice now.
Correct.
I'm sure it's extremely hard because
Right.
this question I want to ask, I probably can't ask it like that. But I'm going to make an assumption that if someone seeks proper legal advice, maybe goes to an attorney that does do this kind of work, maybe makes wills and helps figure out what's there, they would probably be the most qualified to look at what is in the confines of what the law will allow. And the person, while they're still living, can basically have their wishes planned out.
Exactly.
So that when you see that, and as long as it meets the confines of what the law provides for or allows, it's much easier for you to make a decision that this is what this person wanted, they went through the proper channels, they have the right documents. You can then probate it very quickly and easily because you're just carrying out their wishes.
Right.
Is that fair enough?
That's a fair way to say it. I and my staff are prohibited from giving legal advice,
Sure.
and so that's difficult sometimes because obviously we want to be as helpful as possible, but there is a legal prohibition on us providing legal advice. With that said, again, an attorney can generally navigate through this process to make it as easy as possible. So I think that's fair to say.
Well, I'll say this: don't just go to Google a will and how to write it and think that you're legal, because one little thing is not exactly in the confines of the state law. It can really mess you up, and then your wishes can't be carried out maybe exactly the way you want to because of a small typo. So definitely get an attorney to do this. I'll say that.
Well, and I will say in probating an estate and administering an estate, often there are basically, when I was practicing, I would say, if you don't have a plan for your estate, the state has a plan for you. And state law is created to try to do what they believe decedents or people who've passed away wanted to do. I will say sometimes that works, sometimes it doesn't. But one of the things to be aware of is there are generally notice requirements, and so heirs have to be notified that either there is a will or there's not a will, that someone's trying to administer an estate. And the notice, sometimes there's bonding requirements. Often there's reports to the court that are required, annual returns. All of those things are things that can be more burdensome, can increase the cost of an estate, and can cause delay or cause the estate to take longer than someone expects. So again, those are the things that we're required to oversee, and again, we're required to oversee it within the confines of the law. But there are ways to navigate that to decrease the burden, decrease the expense, and decrease the time that's required. So that's one thing to think about.
Well, small experience I'll share that went through. One time we had a delay with something. Obviously, that didn't have that situation exactly come up again. But I had another situation a few years later where someone came to me that someone had passed, needed to sell a property. And I said, well, first question, has your estate been probated? He says, no. I said, well, before I can put your property on the market, we need to go ahead and start that process to make sure that we're ready to go. So they started the process, and the family was not in agreement on to sell or not sell. I think it was maybe like siblings, I believe. The parents that passed, it was the siblings, and someone to keep, someone to sell. They couldn't agree on what to do, so I did the best thing I could do was just walk away. I said, when y'all get this figured out, I'd be happy to help you, but the last thing I wanted to do, or really we couldn't legally, if we couldn't come up with an agreement or they couldn't go to the courts and work it out, either between themselves or let the courts handle it, once y'all figure out what you want to do together and you go through the legal process, then you go with it. But, before you just throw it up to the courts, you may want to really try to work it out yourselves, because that may be better off, because they will come up with an answer for you, and it might not be the one that everybody wants.
And there are a number of different alternatives. Again, obviously, pre-planning is helpful. And knowing, having a plan for what is going to happen with your own estate, and possibly family members if that's possible. We do send a number of estates to mediation. Judge Kaysen had a standing order that required mediation before you actually had a hearing in court, and so that order is still in place, and so we do use mediation a good bit, and that's just an alternative to the time and expense of a court hearing. But again, this court is responsible if you are able to reach an agreement, this court oversees that. If you're not able to reach an agreement, this court oversees that as well. So everything that goes through the estate, this court is responsible. And I will say, we did become an Article 6 court when I took office. So that's based on population. Basically, there's 2 tiers of probate courts. You can have a lay judge if your county population is below 95,000 citizens. So we have had a lay judge. Judge Kaysen was a lay judge up until I took office. And again, she was grandfathered in. She was able to stay and be our judge as long as she was able to be reelected, basically. And so, but with her resignation, we're over the population threshold that now we're required to have an attorney as our probate judge. And so I'm a licensed attorney. And that means that I can have jury trials. And I can settle a number of disputes that in the past would have gone to Superior Court. And so that we're what you call an expanded jurisdiction court, which truly means that almost all estate matters come through the probate court.
Very good. So at some point in time, unfortunately, we're all going to die at some point. So it's it's just
taxes.
That's it. So proper planning definitely makes it easier on everyone. But at the same time, just because there wasn't proper plan doesn't mean that the right resolution can't come together.
Absolutely not.
But just you've got to go through the process the right way. And if you're going to have property that you need to sell, even if you don't need to sell it, at some point in time, you never know what the future holds.
That's correct.
I give the advice, and I don't know if this is, it's just, I call it common sense advice, just from being a practitioner in real estate, that as soon as you possibly can take care of getting the estate probated, go ahead and take care of it when it's kind of fresh on everyone's mind, so that records are all still kind of together. There's things that may need to be requested, documents, whatever it is.
Right.
After someone passes and time passes,
Yes.
things start, well, I don't need that box of stuff anymore. It was just old junk of papers, and it got tossed or whatever, and there may have been something very critical that could have been used to maybe help the situation out. So that's just a kind of, I'll call it just a kind of a common courtesy advice from me that I always give or extend to anyone that I deal with to just going to be going through something, because at some point in time it will come up that that piece of paper is needed, and if you've already done it, it just makes it much easier. I think it also helps with closure.
Well, and notices and consents, often, again, heirs are required to be notified and required to give consent, and as time goes on, other people pass away. That's more people that have
Makes
to
it
be
more
given consent.
complicated.
Maybe you can't find those persons, and that's another makes it a little bit more difficult. So I do think you're right. Whereas time cures some things, there's some things that time tends to make it worse or
Sure.
harder.
All right, one last random question. Is there a generic form for a will?
Again, I can't give legal advice.
I was just messing with you. Ask Judge Edie, but not for legal advice.
Right.